www.videonews.com.
Okay, let's get started. Welcome to a press conference at the Foreign Correspondents Club of Japan. My name is Teddy Jimbo. I'm the co-chair of the committee that organizes all the media events like this one today, and I'm a moderator today. We have three distinguished speakers today. I was very looking forward to present this press conference to you, because I think this is a very, very important press conference and very important case for you to know what happened. I think by now everyone's aware of this so-called hostage justice system of Japan. But I've seen many similar cases, but this is, I think, one of the worst one. A crime was basically fabricated. Very serious crime that one company allegedly exported a machinery to China that can be used to manufacture the biological weapon. I mean, what can be more serious than that? Of course, that's it's illegal to do so. And later on, the police and the prosecutors found out that the machinery that this Okawara Kogyo manufacturer is not capable of making such substance or such product. However, this is where the hostage justice starts. They arrested the senior leaders of the company, held them for a long time, and tried to basically coerce them to confess. So once the confession is obtained, they can easily win the guilty verdict. But in this case, the senior management of the company who were arrested didn't give in. They basically resisted, remained that they did not commit any crime. So in the end, they gave up and dropped the case. And that was the first part of the end of the story. But Okawara Kako hit back, basically struck back with the demanding the compensation from the government. And the judgment at the Tokyo District Court is expected on the 27th of December, which is, I believe, next week. So we invited the three speakers from the case ahead of the sentencing, and two senior management from the company, both of whom were arrested and detained for an extended period of time, and their lawyer today. So let me introduce the speakers today. My immediate right is their lawyer, Takeshi Takada. Tsuyoshi, ごめんなさい, Tsuyoshi Takada. And next to Takada-san is the president of the company, Masaaki Okawara. And my far right is the Junji Shimada. He was a former senior management of the company. Now he doesn't work for the company any longer, but he was also arrested and detained. So we're going to have Takada-san start out speech. Everyone will speak briefly, not longer than 5 minutes, and then we will go to Q&A. じゃあ、高田さんからお願いをできますでしょうか。はい。よろしくお願いします。
高田です。よろしくお願いいたします。私はこのような事件が現代の日本で現実に起きたことが今でも信じられません。
I still cannot believe that such an incident actually happened in modern Japan.
長い夢を見ているようです。
It's like I'm in a long dream.
事の発端は経済産業省による法令の不備でした。
It all started with the deficiency in legislation by the Ministry of Economy, Trade and Industry, METI.
輸出管理に関する国際基準を日本の法令に反映させる際に翻訳の間違いがあり、国際基準と異なる曖昧な規制にしてしまいました。
When the content of an international agreement on export controls was reflected in Japanese legislation, translation errors resulted in ambiguous regulations.
その後、警視庁公安部は多くの噴霧乾燥機メーカーが、経済産業省の許可を受けることなく輸出しているという事実を知ります。そして日本の規制が曖昧であったため、立件できるチャンスだというふうに考えました。
And subsequently, the Public Safety Bureau of the Metropolitan Police Department learned that many spray drying machines were exported without license from METI. And they thought that as the Japanese regulations were unclear, senior investigators thought that they could make a case.
警察は経済産業省に協力を仰ぎました。
And the police sought cooperation from METI.
これに対し、経済産業省は当初、警察の考えには賛成できないと消極的な姿勢を示していましたが、警察は虚偽の証拠を捏造して、経済産業省を騙し、協力を取り付けて、大川原化工機の3人の逮捕にこぎつけました。
Initially, METI was reluctant to cooperate with the investigation by the police. However, the police fabricated evidence to deceive METI, which eventually agreed to cooperate, and then led to the arrest of the three men.
また、警察の捜査に無理がある場合、これを見抜いて制止する役割を有するのは検察官ですが、この事件を担当した検察官は、警察の報告を鵜呑みにして、報告と矛盾する供述が現れたのにもかかわらず、一切の検証を行わず、無実の人を起訴しました。
And it is the prosecutor who has the role of detecting and curbing unreasonable police investigations. But in this case, the prosecutor in charge was totally relied on the reports from the police, and she did not conduct her own investigation, and eventually that led to the arrest of 3 innocent people.
これら捜査の違法性は12月27日、現在我々が提起している国家賠償請求訴訟の判決で、裁判所によって真相が明らかになるものと期待しています。
So we expect that these issues of illegality in the investigation will be brought to light by the court on December 27 in the judgment on the state compensation lawsuit we are currently filing.
本日皆さんにお伝えしたいことは、こうして警察の違法な捜査により逮捕された大川原化工機の3人が11ヶ月間という長い期間、身柄拘束を受けたまま劣悪な環境で戦い続けなければならなかったという事実、人質司法という問題です。
What I want to tell you today is the fact that the 3 Okawara Kakoki employees who were arrested as a result of this illegal police investigation had to fight on in poor conditions while in custody for a long period of 11 months. This is a problem of hostage justice.
日本では自らの無実を主張しているだけで裁判所は逃亡や罪証隠滅の恐れがあるとしてなかなか 保釈をしてくれない、これが現実だということです。
In Japan, the reality is that the courts are reluctant to grant bail to a person who asserts their innocence on the grounds that there is a risk that they will flee or destroy evidence.
以上です。
That's it from me.
Okay, thank you. And Mr. Okawa, please. はい。岡田さん、お願いします。
私は2020年の3月、突然逮捕されました。私はそれまで1年半で40回以上警察に通い、聞かれたことすべてに答えて何通もの供述調書にサインをしていましたので、まさか逮捕されるというふうには思っていませんでした。しかし警察は私に罪を自白させるために私を留置場に閉じ込め、社員や家族、社会からも分断したのです。
In March 2020, I was suddenly arrested. I had been to the police more than 40 times in the previous year and a half and answered all the questions they asked me, so I did not expect to be arrested. And I had told them everything I was aware of in the previous 40 interviews and signed a number of statements, so I had nothing more to say. But in order to get me to confess to the crime, the police locked me up in a police cell and separated me from my family, employees, and society.
逮捕後、私は弁護士さんと相談して取り調べに対して黙秘をすることに決めました。そして黙秘する私に対して警察は弁護士に言われたから黙秘してるんだろう、弁護士の言うことを聞くとそんな場合もあるよと言って、不安を募りました。煽りました。私はこのまま私の身柄が拘束され続けたら会社がどうなるんだろうと心配になりました。
After my arrest, I consulted with my attorney and decided to remain silent in response to the interrogation. And in response to my silence, the police said, "You're keeping silent because your lawyers told you to. But why are you obeying your lawyer? It can be detrimental to listen to your lawyer." And they made me feel uneasy. I began to worry about what happened to the company if I continued to be held in custody.
留置場ではまるで罪を犯したものであるように扱われました。数人の相部屋でテーブルがなく、食事の時は本当に冷たいご飯の入ったプラスチックの容器が床に置かれました。また部屋の片隅に置かれた便器で用を足さなければならない日でした。
In the police cell, I was treated as if I were a guilty person. There was no table in the room that I shared with few others, and at mealtime, a bowl of rice in a plastic bowl, cold and hard, was placed on the floor, and I had to use a toilet placed in a corner of the room.
移動する際には手錠と腰縄でつながれ、監視人からは目を合わせるな、横を向くな、下を向くな、向けと奴隷のように扱われ、大声で怒鳴られました。また、逮捕後の取り調べは片手錠をさせられたまま椅子に縛り付けられて行われました。これも40回を超すものです。
When moving to a different place, I was handcuffed and tied with waist ropes and told not to make eye contact, not to talk, look down, or do not look sideways. And I was treated like a slave and shouted at loudly. And while being interrogated, I was handcuffed in one hand and tied to the chair. and that number of interrogations was more than 40 times.
このような毎日で体力、精神力を削られ、早く出るために罪を認めてしまうのが得策だというふうに悩む日もありました。
So these days drained my physical and mental strength, and there were days when I wondered if it would be a good idea to plead guilty in order to get out as soon as possible.
弁護士さんは裁判所に何度も保釈を請求しましたが、保釈すると社員と口裏合わせをする恐れがあるという理由で却下され続けました。私が11ヶ月間、身柄拘束されながらも戦い続けることができたのは、自分たちは無実であるという強い自負と、必ず無罪判決をもらうことができるという確信があったからです。
And my attorney repeatedly requested the court for bail, but it was continuously denied on the grounds that I would arrange with my employees to make their statements would be consistent. But I was able to fight on while in custody for 11 months because I was strongly confident that I was innocent and that I would be found not guilty.
起訴されて間もない頃、弁護士さんから検察官が起訴した根拠となる証拠に明らかな間違いがあって反証が可能であると聞きました。そしてその無実を明らかにするために社員が懸命に実験を繰り返してくれました。
And shortly after I was charged, my attorney told me that there was a clear error in the evidence on which the prosecution based its case, and that it was possible to disprove it. And in order to clarify our innocence, our employees worked very hard to conduct a series of experiments.
70回以上を超える実験でした。
And the more than 70 experiments they conducted.
必ず無罪になるとの確信があったからこそ、私は戦い続けることができました。
I was able to keep fighting because I was convinced that I would be acquitted.
しかし、たとえ無実であったとしても、無罪判決を取れるか不安なまま身柄拘束をされている方がむしろ多いのではないでしょうか。冤罪をなくすためには、無実を訴えるすべての人が捜査機関と対等に戦うことができる環境が必要です。人質司法の下では冤罪はなくならないと思います。
However, there are probably more people in custody who are uncertain whether they will be exonerated even if they are actually innocent. In order to eliminate wrongful accusations and convictions, we need an environment in which everyone who claims innocence can fight on equal terms with the investigating authorities. I believe that false accusations will not be eliminated under a hostage justice system.
もう一点だけ付け加えさせてください。身柄拘束を受けているか否かにもかかわらず、警察や検察官による取り調べの際、これはぜひ弁護士の同席、録音・録画、最低でもメモを取ることを許すべきというふうに思います。このフェアな取り調べがなされてないこと、警察の有利な調書を、書かせて、それをもとに検察官が判断することが、このようなでっち上げと言われる事件のもとになるのではと思っています。以上です。
Let me add one more thing. Whether you are arrested or not, during the police or prosecutors' investigations, I think that the attorney should be present in the interrogation, and they should be allowed to make recordings, both the sound recording and the video recording, or at the very least, to take memo, to take notes during the investigation. That should be allowed to happen. Otherwise, a fair investigation will not be possible. and that the police would try to make a statement that is only favorable to the police. And based on that statement, the prosecutors will indict a person. And this is indeed the source and the cause of fabrication, such as our case. And I do hope that this will be realized in the future.
Okay, thank you, Mr. Okawara. And Mr. 島田さんお願いします。
はい、私がここで申し上げたいことは、このような冤罪被害者を再び生まないように、警察、検察が反省し、自己検証をし、二度とこのような事件を起こさないような再発防止に努めていただきたいと思っております。
What I would like to say here is that to prevent the similar things from happening, I hope that the police and the prosecutors will reflect, self-examine, and make use of this case in the future, so that this kind of wrongful accusation will not happen again.
この点において、検察は起訴が間違いであったと取り下げたにもかかわらず、捜査を担当した塚部検事は、証人尋問で、起訴した判断に間違いがあったとは思わないから、謝罪も反省する気持ちもない、また同じ状況になったとしても、同じ判断をすると証言しました。
And in this regard, I want to point out that despite the fact that the prosecutors withdrew the indictment, the prosecutor Tsukabe, who was in charge of this investigation, said in her witness statement that she does not feel apologetic because she does not think there was any error in the decision she made at the time, and when she made the indictment. And if she were to go back to that time, she would make the same decision. I still cannot forget the testimony that she made.
すなわち、再発防止もない、これからも同じような冤罪を繰り返すと明言いたしました。私はこの証言に大きな失望と同時に大きな憤りを覚えております。
That means that the prosecutor clearly stated that they will not do anything to prevent the similar things from happening in the future, and that the wrongful accusations would be repeated in the future. And at that statement, I was very much disappointed, and at the same time, I was furious.
警察はなぜこのような違法に捏造事件を起こしたのか、検察はそれを見過ごし、確認もせずに間違った起訴をしたのか、検証すべきだと考えております。
Why did the police fabricated this crime and did such investigations, and why the prosecutors overlooked it and did not do any investigation into that police investigation? And I think there should be a thorough review of this.
それがなければ、日本の警察および検察の信頼回復はないと思っております。
And without it, I believe there will be no regaining of confidence in the Japanese police and the prosecution system.
同僚の相嶋さんは、間違った起訴勾留により、劣悪な環境下に拘束され続け、保釈も認められず、適切な病気治療もなされず、他界しました。
And my coworker, another person who was arrested and indicted, Mr. Aishima, he was indicted and detained based on the wrongful charge, and then put in very poor conditions while in detention, and without being admitted to bail, and while still in detention, he died because he could not receive proper treatment.
ぜひ疑いがあるというだけで長期身柄拘束が正当化され、精神的に追い詰め自白を求める今の人質司法は一日も早く是正され、二度とこのような冤罪事件が起きないようにしていただきたいと思います。
So I do hope that this hostage justice system should be eliminated, where the people are pushed into the corner mentally and coerced into confession to the crime that they did not commit. And in order to prevent this kind of thing from happening ever again in the future, I do hope that the people will address this issue and that the remedies are taken.
Thank you very much, Mr. Shimada. ありがとうございました。Just for your information, Mr. Aishima, Shizuo Aishima, one of the 3 executives who were arrested, died of stomach cancer while he was in detention, and his request for bail was declined 8 times, and he could not receive a proper medical care and died while in detention. And also, the 2 gentlemen here today are detained for 331 days, until the prosecutors decided to drop the case. And also another piece of information, the Okawara Kakoki is suing the national government, and the Tokyo Metropolitan Department as well. The Tokyo Metropolitan Government as well. The national government has the oversight over the prosecutors, and the Tokyo Metropolitan Government does have an oversight over Metropolitan Police Department. So they are the 2 bodies that the Okawara Kakoki is suing, and they are demanding 565 million yen for damage. Okay. So those are the facts. And another important piece of information. Our interpreter today is Mieko Fujioka. Fujioka-san, yoroshiku onegai shimasu. Okay, so we're going to go to Q&A. Please raise your hand. If you're designated, come forward. There are 2 microphones in front. So come forward and cite your affiliation, and let's limit to questions only, no speeches. Anyone who want to start first? Anybody? Okay, go ahead.
Mary Corbett, Kressner Media. You mentioned that there is a lawsuit pending right now in the courts. I was wondering if your arrest impacted company sales and clearly reputational damages. Is that included in the 565 million, or are you going to pursue other venues after this?
クリスチャンメディアです。国賠訴訟の件についてお伺いいたします。今回のその皆様が逮捕された件で、会社の売上、そしてもちろん評判にどのような損害がありましたでしょうか。そしてそれは今請求されております5億6500万円のこの損害賠償請求の中に含まれているんでしょうか。それともこれについてはまた別途違う法途で請求されるということなんでしょうか。
どちらが、小原さん、いかがですか。はい、どうぞ。
売上の減少は、約 40% ダウン、いわゆる6割の売上に、なりました。その結果ですね。で、 信用不安については、我々のお客様の方は、我々のことを理解してくれて、従来取引のあるお客さんについては、ずっと続けて、信頼してくれていました。ただ、実際に我々が物を買う方ですね、モーターであるとか、ポンプ、ブロワーであるとか、そういうふうなものを販売している大手の会社、それから電気製品ですね、コントロールユニット等を購入するということが、直接購入するということができなくなりました。そのために、協力会社から、現金先払いで、現金先払いをしないと、機器を買うことができなくて、資金繰りには、だいぶ苦労をしていました。
Yes, our sales went down by 40%. And as for reputational damage, there was not a problem with our existing customers, because our customers had very good understanding. So we didn't have any problems with the existing dealings with the existing customers. But we did have problems when we are trying to purchase the equipment and the parts and so forth. For example, motors and pumps and blowers, when we could not buy them from a major supplier of those equipment. And the same thing can be said of the electric equipment, such as control unit and so forth. We could not buy them directly from those suppliers. So we had to buy them from our subcontractors, but only on the condition that we pay in advance in cash. So that did cause some financial problems for us in order to run the business.
金融機関については、銀行の方は、取引が、いわゆるストップされる、貸してもくれないし、返すこともしないという状態で、今持っている現金だけで、仕事をやらなくちゃいけないということになりました。
And as for financial institutions, all dealings with the financial institutions had stopped. That means that we could not borrow money from banks, and nor could we repay the loans that we already had with those banks. So we had to do our business only with cash on hand. Otherwise, we couldn't run our business.
それは逮捕されてから、取り下げが、検察の取り下げが終わった1年半、さらに、長引いて、実際には2年近く金融機関からは、取引が停止しているという状況を受けました。
So that situation lasted from the time of our arrest until the time when the prosecutors dropped the case. So that's 1.5 years. But actually, this stoppage of the dealings with the banks lasted a little longer, close to 2 years in total. And so during that time, we had no dealings with the banks.
訴訟ですけれども、このようにその会社は非常に大きな損害を、売上減ったりとか、資金繰り圧迫されたりとか、そういう損害を受けたんですが、今回の訴訟、5億数千万円訴えてますが、そこには今回のその会社の売上が下がったことによる損害というのは含めていません。また、今後、それを国に対して補償を求めるということも予定していません。
And as for this compensation lawsuit, although the actually company did incur some losses because of the sales down and also the financial problems, but actually the amount of money that we are seeking, 500 some million yen, does not include the losses coming from the losses that we incurred in our businesses. We do not have any plan in the future to seek compensations from the state about that loss.
Okay, next question. Anybody? Karin-san.
今回の記者会見ありがとうございます。ラジオフランスと、リベラション新聞の特派員で西村と申します。よろしくお願いします。今回の件で逮捕される前に検察と警察についてどう思っていたのでしょうか。信用してたのでしょうか。それは1点目。2点目はそういったひどい扱いということは組織的なことであるのか、それとも、その中で個人もいるんですよね。その中で個人はそれをやってることは本当にダメと思ってる人がいるかもしれないけれども、誰も声を上げてない、ストップしましょうとかってないみたいですけれども、どう説明できるのでしょうか。
Thank you for having this press conference. This is Nishimura. I'm a reporter for Radio France and Libération. And before your arrest, what was your view about the police and the prosecutor's office? Did you have trust in them? That's first question. And the second question is that do you think it is an organizational problem that the police and prosecutors have? But I'm sure there are some individuals in the organizations who thought that this kind of thing should not be allowed to happen. However, nobody actually stopped the organizations to go on with this investigation or the prosecutions. And why do you think that is?
まず逮捕前、警察を信用していたかどうかということなんですけど、もちろん、我々任意の捜査が入った後に、自分たちが、本当にどういうふうになってるんだろうかということを自分たちで確認しながら、警察の、取り調べに全面的に協力していくということを、社員に、話しました。で、その結果、社員約50名弱の社員が取り調べに応じて、取り調べのその、回数は、290回くらい延べですねの取り調べに応じました。もちろん警察はちゃんと、こちらが言ってることを調書として、残してくれるというふうに思って、協力をしてきたつもりです。で、さらに、我々の方この装置が、規制の対象になるかもしれないというふうに言われていましたので、すべての機器、その捜査があった以降のすべての機器について、すぐに、許可申請を出すように、社内の方に、徹底しました。ですから、 是正をちゃんとされて、我々是正をしている、それからやっていることは、やったことっていうか、実際に自分たちが調べて、該当しているものがないということを確認していましたので、社員も含めて、我々も含めて、自信を持ってというか、自分たちは、何も悪くないというふうな、形でいましたので、なんですかね、疑うようなことっていうことは、警察を疑うようなことはしていませんでした。
Yes. About your first question, whether we trusted the police before our arrest. So when the police investigation started, we actually, reviewed and made sure what was happening with our equipment that we exported, and we decided to cooperate fully with the police investigation, and I instructed my employees to do so. So overall, about 290 times of interrogations were conducted with about 50 employees of our company. And we thought that our claims and explanations would be properly put into the statements that the police would make. And that would be okay, we thought. And we also conducted a thorough review of our equipment which are exported. Because indeed, the equipment that we produce, spray dryers, some of them may fall under the restrictions under the export control law. And we confirmed that our equipment would not fall under such specifications subject to export control. So we did all we could do to correct the issues, and we actually applied for a license, the permit from the government to export our equipment. And so we did everything that we thought we should do, and we conducted our own review of the equipment and confirmed that our equipment are not subject to the export control. Therefore, we were confident, and we therefore did not really, put questions to the police investigation.
補足します。
お願いします。はい、いいですか。
逮捕される1年半前に、任意の取り調べが始まりました。その時は会社の考えをしっかりと伝えれば理解してもらえるというふうに考えていたので、全面的に捜査に協力して分かってもらおうという方針でずっとやってきました。その中で取り調べが非常に過酷な取り調べがなされることが途中ありました。その時は私の方が警察に電話をして、こういうことはやめてほしいと、やりすぎだというようなことをクレームを入れたりもしましたが、ただ原則として方針は変えませんでした。しっかりと伝えて、こちらの考えを伝えれば理解してもらえると。すごく難しい法律ですので、やはり警察の方も理解するのが大変なんだろうというところで、しっかりと伝えていくというのをやりました。しかし今分かったのは、警察はそういうことを考えてなくて、とにかく逮捕する、とにかく立件する、それだけを目的に取り調べを行っていた。だからこちらが言ってたことはまともに聞いてなかったんです。それが今は分かりました。当時はそこまでひどいとは思ってなかった。そういうことです。あともう一点、逮捕された後の生活が過酷っていう、人間の暮らしとして非常にその尊厳を害するようなひどい暮らしをさせられるというところですけれども、残念ながら日本ではそれが普通になっている。それに対してもちろんその過酷な環境は人質司法の問題として許されるべきじゃないという 人たちは一定程度いますけれども、日本のシステムは、残念ながらずっと変わっていないというところです。この事件に限ったものではなくて、日本のシステム全体がそういうのを許しているというところだと思います。
お願いします。
A year and a half before the arrest, the police started the investigations and we were voluntarily asked to cooperate with that investigation. And initially, we thought that if we made a proper explanation to the police, then they would understand. That was our stance. That was our policy. And although there were at times very severe interrogations with our employees, and in such times I would call the police and to tell them to stop such severe interrogations. So I did make some complaints, but overall our policy was that we would make a proper explanation so that they would understand. And we hoped that and we thought that they would understand, because this is a very tricky technical legal issues involved. It might be difficult for the police to understand fully. So we thought that we are going to make a full explanation to them so that they will understand. But in hindsight, we now know that the police did not have any intention to understand the issue. Their sole purpose was to arrest us and to make a case. We now understand that, but initially, and in those days, we did not understand that. And in terms of how we were treated after our arrest, unfortunately, in Japan, the person who are arrested and detained are violated in their dignity, and they are not allowed to live humanly. And unfortunately, this is the case in Japanese system currently. And there are people I know that these are the issues with the hostage justice system. However, unfortunately, this is the system in Japan right now, and and it's not limited to our case at all. It can apply to many other cases. So this is a systematic issue.
Okay, just for your information, the President Okawara mentioned that there was no videotaping or no recording of the interrogation, and of course no lawyers allowed to be present in the interrogation room. Lawyer is never allowed in the interrogation room in Japan. However, there was some change in recent regulations, and certain cases involving the jury trial and also Tokusou jiken, the cases involving the special investigation unit of the prosecutors are required to record the interrogation, but that only constitute the 3% of all cases. So 3% of all the cases are required to make the video recording of the interrogation, but the case like this, no recording, and even taking notes were not allowed. So that's how the hostage justice system works in Japan. Let me just do a follow-up question on the previous one. 一つだけちょっと日本語でお伺いします。お二方、それから高田先生はですね、今回のケースというのは特に公安事件なわけですけれども、公安警察が最初は例えば輸出管理令に対する無理解からわけわからずにやったと思い込んで走り出してそれが止まらなくなったケースなのか、それともですね、とにかくもうこれNHK のドキュメンタリー見てそういうあれがあったのでちょっと僕は影響を受けてるかもしれないですけど、そもそも事件が必要なんだと。公安はもう公安事件があんまりなくて、もう組織の存続がやばいからとにかく事件が必要なんで、でっち上げだっていうように分かっててもとにかくやってしまえっていうようなものだったのかっていうのは、これもちろん推測になるんですが、実際に皆さん方が接してきてですね、 最初のうちは無理解だったのかなとか、それともこれはもう最初からそのつもりなのかなっていうようなちょっと感触があればぜひお伺いしたいんですけども、いかがでしょうか。ちょっと翻訳だけ入れさせてください。お願いします。藤岡さん、すみません。
My question is that so this is a case investigated by the Public Safety Bureau of Tokyo Metropolitan Police Department. And do you think that this case started out firstly with the lack of understanding of the ordinance related to the export control law, but somehow down the line they just did not know how to stop the case? Or do you think that maybe the Public Safety Bureau actually did need cases, and otherwise, their survival as a unit, as an organization, would be at risk? So that's why, even if they knew that was a fabrication, but they anyway went along with it. Which do you think was actually what happened? Of course, just about your feeling of this case. Do you feel that maybe initially the police had this lack of understanding, and that is why this investigation started? Or do you think that the police had from the beginning a foregone conclusion of arresting the 3 persons?
いかがでしょうか。じゃあ高田先生からどうぞ。いや、じゃあ社長からどうぞ、ぜひ。はい。はい。補足していただいた方がいいから、多分だから。はい。
この初めに捜査に入った時に我々の中でもちょっと話をしたのは新しく法律ができた。で、噴霧乾燥機が規制対象になった、それはもともとが、2001年の 9.11 の事件の時に炭疽菌封筒事件というものがあって、生物化学兵器がテロに使われる可能性があるということで、噴霧乾燥機が加えられたんですけれども、それを法律化するということを経済産業省から我々の会社の方に問い合わせがあったりしたんで、それに関してだなということはまず分かって、しかもその当時やはり米中関係、アメリカでトランプ大統領が当選されて大統領になってから、米中関係がちょっとおかしくなってきた。でさらに、日韓関係もおかしくなってきた。で、一部では経済安全保障の話も出てきていた。でさらに、外為法の罰則も上がってるということで、いやこれは無理やりというか我々の方をまずターゲットっていうんですかね、やり玉にしたんじゃないかな。ちょっとこちらとしては間違ってるのに、何をするんだっていう感じだったんです。で、その後実は島田の方で、にあってはならないところにお宅の機会があったっていうことがあって、ひょっとしたら、このリスト規制ではなくてキャッチホールで何かあったのかなっていうふうに実は私の方は思いました。
それ中国っていう話だったんですか。あってはならないところっていうのはもうその段階で。
それは、
中国ってことだったんですね。
ここまでよろしいですか。
And when the investigation first started, we had some discussion internally in our company, and because there was this new law on the restrictions of the export, and the spray dryers, the equipment that we were producing, became, were subject to these new restrictions. And to the background was this terror incidents in 9/11 terror incidents in 2001, and there was also the anthrax envelope incident. So there were concerns that the biological weapons would be used by terrorists, and the spray dryer could be used potentially to produce biological weapon. And so when the new regulations came into force, METI actually consulted our company about this spray dryer question. And so initially, when the investigation started, we realized maybe this was the case. This is about this case. And then in those days, the U.S.-China relations were becoming very tense. It was after President Trump was elected. And also the Japan-Korea relationship were also strained at that time. And there were also, talk of some economic security issue and so forth. And also there was amendment to the foreign exchange law to make certain provisions more severe than before. Therefore, initially we thought that maybe we are targeted in our equipment. And we were thinking, what are you going to do to us? And then to Mr. Shimada, police one time told him that we found your company's equipment in a place where it should not be. And so we thought maybe this is not about the list restriction case, but maybe it is about this catch-all case.
はい、じゃあ私の方から今の質問に対して私は完全に意図的な捜査だと思っています。それはなぜかというと、今社長が話したように、あってはならないところにあなたの機械が納入されてるんだということを聞いて、これは大変だと思いました。で、すぐに私どもの、全納入先を提示して、さあここにどこにあるんでしょうかって提示したら言を変えて、いやそういうことは言ってないと、今捜査中だというふうなことはありまして、私は先ほど警察を信用していたかという話がありましたけれども、最初は信用しておりました。ただそういう嘘をつく、誘導する、恐喝する、そういうふうな、あるいは書類を入れ替えてしまうとかいうことが何回かありましたんで、逮捕以後はもう全く信用しておりませんでした。
Yes, I think the police had fully, intentionally started this investigation. When I was told by the police that they found our company's equipment in a place where it should not be, and then I immediately presented them with the list of all the places and companies that we supplied our equipment, and asked the police to pinpoint where they found our equipment. And then the police said, no, we are still investigating. And they retracted their remark. And so initially, yes, I trusted the police, but because of repeated lies and some coercions and other cases in which the documents were substituted with others, and in some cases. And after all this, and after my arrest, I totally lost my trust with the police.
Okay, thank you very much. I think we are running out of time, but do you want to go? Okay. じゃあもう2問だけいいですか。じゃあちょっとお願いします。じゃあ手短に。じゃあどうぞ。はい。
すみません、フジテレビ中川です。今日はありがとうございます。社長にお伺いします。来週判決が出るということで、率直にどういう司法の判断を期待されていますか。それとしてやっぱりいろんな証言が出ましたけれども、違法捜査であるということが裁判官にどのように伝わっていたかなど、来週への思いというかどういう判決を期待するかを短くお聞かせください。
Question to Mr. Okawara. So what is your expectation of the ruling to be handed down next week by the Tokyo District Court? And there were many different testimonies made during the trial. And to what extent do you think the judges understood the nature of the investigations which were illegal?
警察、警察に対しては、やはり証言でも出たように、自分たちが、作った事件であるということを、正直に、認めるような、意味の判決になっていただきたいというふうに思いますし、実際に検察、それから裁判所も保釈が、なかなか認められなかったということもあって、おのおの反省するところがあったんじゃないかというふうなこともぜひ判決というか、裁判長さんの意見として出てくることを、私としては期待したいと思っています。
As for the police, during the trial, there were witness testimonies to the effect that the actually police did fabricate the case. And I do hope that the ruling will recognize that in the ruling. And as for the prosecutors and also the court, because they repeatedly denied bail for us, so I think each institution has its own things that they should self-reflect on. And I do hope that the ruling will finally reflect on all those points.
おかげさまで事実のことは報道機関の方から、いろいろ取り上げていただいて、隠れたところまで、現れてオープンになってきたということで、本当に、そのことについては感謝しています。
As for the facts, thanks to media reporting, various points which were previously hidden were also revealed and brought to the public, and for which I'm very grateful.
一点補足しますけれども、今回の訴訟では裁判所のその保釈をしなかったっていう裁判所の責任については問題視していません。問題のターゲットに置いてませんので、今回の判決はあくまで、捜査の違法、警察の捜査、検察官の起訴、それの違法について判断が出されるということです。
Just to add, in this complaint lawsuit, we did not target the responsibility of the court in terms of the denial of bail. We targeted on the responsibility of the police and the prosecutor's office in terms of their investigations and indictment. and the illegality of them.
Okay, if anyone wants to ask him why, you can do that later. いいですか、大丈夫ですか。はい。じゃあ最後に一言だけ、今回裁判所入れなかったっていうのはあれですか、やっぱりその訴訟戦略上のなんか判断ですか。これを入れちゃうと裁判所はあんまりフェーボラブルな判決をくれないかもしれないみたいな、そういうあれですか、やっぱりこれは。
You did not target the court in this complaint lawsuit this time. Is it because of the strategic consideration that if you did, it might lead to unfavorable judgment?
訴訟を提起するときにどこの責任を追及するかは検討したんですが、すべての期間を対象にしてしまうと問題が大きくなりすぎて時間がかかる、解決に時間がかかるため、確実に攻めたい部分というのに絞って訴訟を今回は提起したと。その結果、裁判所の保釈の問題というのはターゲットから外しましたけれども、決してそれは我々が問題ないというふうに考えているわけではなくて、あくまで戦略上の話だというところです。
Yes, before we filed the lawsuit, we thought about where we should put our targets on, and if you target all the institutions, and that will make the case very big, and that means a very long time before the ruling is handed down. So we decided to focus on very important core points that we wanted to target. That is why we did not target the question of the denial of bail by the court, but that doesn't mean that we do not think it's important. It was solely out of the strategic consideration.
Okay, thank you very much. Okay, I think we're going to wrap up this press conference today. 会見の後、名刺交換くらいはできますか。じゃあ、Okay, so speakers will remain here. So if you want to come forward and exchange name cards, please do so. And the ruling on the 27th of December will be given at 2 p.m. 2 p.m. on the 27th of December. That ruling at the Tokyo District Court will be given. And also, one last thing, we have Kanae Doi, the Japan director of Human Rights Watch. She's also involved in this case, and she is, of course, fluent in English. So if any English-speaking journalist wants to ask questions, she'll be available afterwards. So please use the case. Okay, so thank you very much for coming for the press conference, and thank you, お三方どうも本当にありがとうございました。それから藤岡さんもありがとうございました。Thank you very much, and I'm going to wrap up this press conference.
ありがとうございました。